5 seconds to go. Start. Section 39, which pertains to the offence relating to sport given to terrorist organization, fall under Chapter 6 of the said Act. Section 43D, which was inserted by Act 35 of 2008, pertains to the modified application of certain provisions of the Code of Criminal Procedure. Subsection 5 of Section 43D being relevant for the purpose of these appeals, the same is reproduced hereunder. Notwithstanding anything contained in the Code, no person accused of an offence punishable under Chapters 4 and 6 of this Act shall, if in custody, be released on bail or on his own bond unless the public prosecutor has been given an opportunity of being heard on the application for such release, provided that such accused person shall not be released on bail or on his own bond if the court, on a perusal of the case diary or the report made under section 173 of the code, is of the opinion that there are reasonable grounds for believing that the accusation against such person is prima facie true. Since all offences alleged against the respondents are covered under Chapter 4 and 6 of the UPA, the rigours and restrictions of subsection 5 of section 43D would apply to the facts of this case. It may be noted that this court, in the case of National Investigation Agency versus Ahmad Shah Supra, had an occasion to deal with the subsection 5 of section 43D, and in similar fact situation, after comparing the similar provisions under the special enactments such as TADA, Makoka and DPS, as also the earlier decisions of this court had held as under. By its very nature, the expression prima facie true would mean that the materials evidence collated by the investigating agency in reference to the accusation against the accused concerned in the first information report must prevail until contradicted and overcome or disproved by other evidence, and on the face of it shows the complicity of such accused in the commission of the stated offence. It must be good and sufficient on its face to establish a given fact or the chain of facts constituting the stated offence unless rebutted or contradicted. In one sense, the degree of satisfaction is lighter when the court has to opine that the accusation is prima facie true as compared to the opinion of the accused not guilty of such offence as required under the other special enactments. In any case, the degree of satisfaction to be recorded by the court for opining that there are reasonable grounds for believing that the accusation against the accused is prima facie true is lighter than the degree of satisfaction to be recorded for considering a discharge application or framing of charges in relation to offences under the 1967 Act. It was further observed a priori the exercise to be undertaken by the court at this stage of giving reasons for grant or non-grant of bail is markedly different from discussing merits or demerits of the evidence. The elaborate examination or dissection of the evidence is not required to be done at this stage. The court is merely expected to record a finding on the basis of broad probabilities regarding the involvement of the accused in the commission of the stated offence or otherwise. From the analysis of the impugned judgment, it appears to us that the High Court has ventured into an area of examining the merits and demerits of the evidence. For it noted that the evidence in the form of statements of witnesses under section 161 are not admissible. So,